All right, we're all set.
Got it. Good afternoon, everyone. Thanks for joining us. Let me start with the required statement. Members of the committee are hereby advised of their duty under the State Ethics Act to avoid conflicts of interest and the appearance of conflict, and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest or an appearance of conflict. Julie, are you raising your hand to point out a conflict?
No, now I can hear. I was giving a thumbs up to Peter.
Okay, got it.
Sorry.
All right, sorry. All right, no one has raised a conflict, so we shall proceed. Obviously, if any conflict arises as we proceed, then hit your raise hand feature or just get our attention and we'll proceed accordingly. The first item of business, and we will go down the agenda as you have it, is approval of the minutes. You have received those minutes and hopefully you had a chance to review them. At this point, I will entertain a motion to approve the minutes.
So moved.
Second.
All right, it's been properly moved and seconded. Any changes or comments or discussions relative to the minutes? Hearing none. Peter, we're going to use the poll feature here.
Yes, I just launched it.
All right, please vote.
We have a unanimous vote here, Todd.
Okay, thank you all. We've got 5 or 6 items on the agenda, several of which will require updates and others will require action. So the first, I'll start with the second item on the agenda, and that is the report on the compensation of court-appointed defense counsel. You received that report at the October meeting from Judge Cobb. It was an excellent report, and we have some distribution issues and or other updates that will be provided by Peter, as I understand it. Peter?
I think it's supposed to be me, but Peter, you can.
Oh, go ahead, Alice. You go ahead on it.
Alice, you have that one? Okay. Go ahead,
Yeah,
Alice.
I'll do that. So the, oh, actually, Peter, this is you. You go ahead.
I thought it was Peter. You got the next one.
We distributed the report to all of the named stakeholders that we mentioned at the meeting when the report was adopted. We sent a copy of the report to various bar associations, government entities, the governor, attorney general, and AOC and the Supreme Court. And so this has been distributed far and wide. We are prepared at any given moment to have it also available on our website. The links are all prepared and ready, and we wanted to confirm with the committee that it was the committee's preference that we do have these reports linked and available on our website. And if that's the case, then they'll be up tomorrow.
If anyone has any issues, please let it be known now, or Peter shall proceed. Judge Cobb, do you have anything that you want to add? It was your great report, so I want to recognize you before we move on.
No, I don't. Just want to thank again the staff that worked on that so hard. And I'm not part of the feedback portion of this, so glad to hear Peter got it out and it's being well received.
All right, thank you. All right, we shall proceed with the second item on the agenda, which is an update on the report of the Secure Leave Subcommittee. That report was given in October by Gordon Brown, who's on the call, and it too was an excellent report. So Alice, I believe this is yours. You want to give us an update?
Yeah, thank you, Todd. I apologize that I jumped the gun on the earlier item. Yeah, the secured leave report at the recommendation of the officers and Mel Wright was sent by me to Trey Allen, who's general counsel for AOC. That Mel was the one we were really looking to because working with the Chief Justice's Commission on Professionalism, he was involved in some of the work on that report, and we felt like we needed to kind of include them in the process. Due to a little miscommunication, I have not been able to speak directly with Trey Allen. He just literally sent me a message right before this committee meeting. So I'm going to set up a time to talk with him. But we are assured that the AOC is the place that is well suited for reviewing the recommendations and that they are planning to vet the proposal with the judicial conferences, which in a meeting this morning of the officers and the Chief Justice sort of emphasized that we really needed to get the judiciary on board with the recommendations in the report. So it's my understanding that that piece of it is underway. That also the upper level management at AOC is looking at the report and they're looking at whether e-courts can help provide the thing that I think the report recommends, which is a sort of uniform application for lawyers to apply for secured leave. So they only have one place they have to go to post the request. So it's my understanding that aspect of it is at least in the early stages of being investigated and that that message has been heard. And it's my hope that once I can talk directly with Trey Allen, I can get a little more substance on where it is with AOC and whether there is something more that we could be doing to really push the recommendations forward. And my intent is to get maybe Gordon involved in that because I know this is near and dear to his heart. And so maybe Gordon will even like hook you into the conversation with Trey. I'll chat with you about that.
Thank you, Alice. Gordon, I'd first ask you if you have anything that you want to add since that was your report. You're on mute.
It's currently in the right hands and I have a lot of confidence in them.
Okay, thank you. So do we. Any other person on the call here who has any questions for Alice before we move on? Seeing none, we shall move to the next item, which shall require some action by us. It is the report of the subcommittee to study proposed regulatory changes in other jurisdictions and potentially in North Carolina. It's been a very busy subcommittee since 2020. It has been chaired by Mark Enriquez and a great subcommittee. And so without further ado, I shall turn it over to Mark to give us his presentation.
Thank you, Todd. It has been a lot of fun. I want to thank the members of the Issues Committee that have been on it. And I need to start by thanking Brian Oten, who's done just yeoman's work helping to understand what's going on in other jurisdictions, summarizing it for us, organized a great series of speakers and presenters from legal aid to different states, even other countries. Got a presentation on the paralegal program in Ontario, Canada. Brian's just done a great job. And I think we've learned a lot. And that was really our mission when this was created 2 years ago. Our mission was to study what is going on elsewhere and then make recommendations into those areas that we think merit development or further proposals. So that is what we have done. We finally finished that work after 12 meetings over a period of 18 months. And we presented a report, which is in your materials. We decided to keep it on the short side with links to all the various materials. There are thousands of pages of reference material, including not only the videos of all the meetings and the meeting minutes, but also PowerPoints, reports, other things that we received from other jurisdictions. I thought I would just briefly summarize the report, the recommendations coming out of that report from this group. The first is one you've already heard me talk about. I talked about it this past summer when we were all in Asheville, and that was a recommendation to pursue a limited license for non-lawyers and paraprofessionals. Our committee concluded that there were areas where paraprofessionals may be able to provide services to improve access to justice. And so we unanimously recommended implementation of developing a program that the council could then consider regarding a separate licensure for non-lawyers to perform legal services. That recommendation has already been adopted by the executive committee back in the July session. So I won't spend that much more time talking about it, although I'll talk about how it relates to some of our other recommendations. The second recommendation is to pursue a regulatory sandbox. I know that term may be new to some of you. Hopefully some of you got to attend the excellent CLE that was put on by Jeff Kelly last week. I think it provided a great overview, and I imagine that's recorded and available if you missed it, to talk about what a sandbox is. In short, the idea of a regulatory sandbox is you create a system where folks can present proposals that say they want to address a need, and here the focus would be improving access to justice, and how they would do it, how they would measure the impact, and how they would measure any potential adverse impacts on the public. The logistics of who's going to be the regulatory body reviewing those proposals, how they'll be presented to the state bar for approval, are definitely things that would need to be worked out in terms of the particulars of a regulatory sandbox program if we decide to pursue it. I think there were two major positives of the sandbox approach that we talked about in our committee. The first is that you're really open to a variety of different proposals, including some of the other ideas that I'll talk to you about in a minute that we recommended. So it is not one change, it's an openness to considering and evaluating other changes. The other idea is you're really doing it in a test environment that's not going to last forever, where you can measure improvement, where you can see what objection is, so you can build support for potentially a more permanent change by testing it in the sandbox. The last thing we talked a lot about is from a practical standpoint. Right now, there seems to be a legislative appetite for it. Our North Carolina legislature this last session adopted a regulatory sandbox in the financial area, where financial companies could come forward with sandbox ideas and be exempt from some of the normal financial regulation. That got bipartisan support from our legislature. And we think the time may be good to pass a similar sandbox proposal in the legal field, given the bipartisan support. And it's something that a number of other states have looked at, including Washington State, Florida, and British Columbia. So that is a recommendation that we think the State Bar Council should pursue, is the idea of developing a regulatory sandbox. And that would involve a committee looking at what the components are, how it's going to be implemented. And, there's a lot of logistics to talk about. I want to finish the rest of the recommendations, and then I'll come back to give you a recap of our final meeting of our committee in terms of next steps. We did discuss a court navigator program. That's not something we think the State Bar Council should do, but it's something other jurisdictions, in particular New York, have had a lot of success with. The idea is you get non-lawyers in the courthouse to help pro se people that don't know what they're doing, and basically serve as guides to say, this is the courtroom, this is what's going to happen, here's how to help you be ready. New York expanded it after a lot of success. And they found it's a great way to render services to pro se folks that can't afford attorneys. Our recommendation is that the council formally requests the Administrative Office of Courts consider implementation. A little like what we did with secure leave, this is a handoff recommendation, not one that we would do directly, but one that we think is worth pursuing. We talked about and do not recommend pursuing alternative admission to the bar. That was one of the few things we talked about that we just did not feel there was enough reason to justify expenditure, further effort on that kind of program. We did recommend thinking about changes on alternative business structures and some restrictions on fee sharing. We think there may be opportunities to serve underserved clients by removing some of those strictures, although they have to do it in a way that's thoughtful and avoid some of the other challenges. We looked at what New York and Arizona did in that and found some merit. We bottom line concluded was that probably the best way to explore some of those changes on fee sharing and other stuff would be through a regulatory sandbox where people could come forward with particular proposals that they think they could do a better job providing access to justice if they could be exempt from one of our regulatory rules, and then we could assess the impact and potential risk. And we reached a somewhat similar recommendation on unauthorized practice. I think there were some areas where we felt that perhaps non-lawyers could do more in terms of drafting documents, certain types of municipal or tax issues, perhaps some pro bono non-lawyers in certain areas. Like the prior recommendation, we thought perhaps the regulatory sandbox would be the best way to explore those issues as well related to the unauthorized practice of law. So where does that leave us? Well, we have two clear, I think we all agreed as a committee that the priority recommendations were the limited licensure and the regulatory sandbox. We had a lengthy meeting in December to talk about what the right sequence was. And I think it's fair to say we were split as a committee between whether to pursue to go first with a limited licensure or first with the sandbox, or try to do both at the same time. So we did not adopt any timing recommendation. We did not get a majority in favor of that. So what we are presenting are both recommendations, both the limited licensure recommendation and the regulatory sandbox back to this issues committee. And that is a summary of the report from the issues committee.
All right, does that conclude your presentation, Mark?
Yes.
Okay, and so the specific recommendation to the issues committee would be what precisely?
I think our recommendation, we previously recommended the pursuing, having a committee develop paraprofessional licensure. We would now also recommend that a committee be developed to explore the idea of a regulatory sandbox and put together a detailed proposal for the council to consider.
All right, that is the recommendation of a subcommittee, which does not require a second. Does anyone else want to be heard? Mac, I see your hands up. Mac.
Thank you, Mr. Chairman. As Mark has said, this was a very long and detailed study, 18 months. It was a 2-year process. It is an enormous amount of information to try to process. But I think that because of the newness of the recommendation for the sandbox, this topic deserves an in-person discussion and debate. There's nothing about this that is so time sensitive that delaying this to April would make a difference. And I think it would give the rest of the committee members who were not part of this subcommittee a chance to study it in a little bit more detail before we have what I expect to be a fairly robust conversation about the final recommendations. I would note for you, Mr. Chairman, that by my count, only 4 members of the present issues committee were on this subcommittee. So the rest of the committee will have some serious homework to do to be ready for what I do anticipate to be a robust and fascinating debate, but one that would be much better held in person. If it's appropriate, I would move that we defer this matter to April.
I know I'm going to be checked here by the parliamentarian Alice, but my understanding is that motion to postpone would take priority over the main motion, and if it receives a second, then it is to be debated first. So is there a second of Mac's motion?
A second, Todd.
Catherine Fry has seconded the motion. And so Alice, check me if I'm wrong, but now understanding is that we will have debate on Mac's motion and then a vote on whether to pass Mac's motion. And if it passes, then that motion will lead to the postponement to the April Issues Committee meeting. Is that consistent with your understanding, Alice?
Yes, that's correct.
All right. Mac's motion has been properly made and seconded, and now it is open for debate. So what is the, I can't see everybody's hand. So Peter, if you see hands go up, please help me out here. Comments from the committee?
I feel like the silence and the fact that you can't see everybody kind of speaks to the point.
Yeah, I'm actually clicking back and forth trying to see if anybody's raised their hand, quite frankly, and I don't see anybody.
It's a tough way to proceed.
All right. I don't see anybody's hand. I'll for what it's worth, I'll give you my experience, because we quite frankly have had some of the same concerns about robust discussion and debate, and we're going to take up the D&I report next. And I've heard this from other folks as well as they have met. And the consensus sort of has been that the in-person discussions of these important issues have been much more beneficial, much more transparent, and much more robust than trying to do this by Zoom. And I think that's the consensus that I've heard. Other folks may have different views. And so with that, I will look again and click on my screen here to see if anybody has their hands up to be recognized. I don't.
I do not see any either, Todd. And if you're trying now, you could simply unmute and begin talking if we don't see you, but I don't see anyone.
All right, it's been properly moved and seconded that the presentation has occurred, but that the discussion itself this does not detract from Mark's presentation in any respect, just the discussion of the presentation be postponed to the April meeting. Hopefully that will be in person. So that is the motion on the floor. And so, Peter, will you go ahead and launch a poll?
I'll launch the poll, and just as a reminder that the voting should be limited to the members of the Issues Committee. Todd, we have 19 votes, and it's all 19 in favor of the motion.
Okay, then the unanimousness of that motion means obviously that it passes and that the debate on this great presentation, Mark, shall be postponed until the April Issues Committee meeting, ideally in person. Alice, have I handled that correctly under our rules as you understand them? I believe so.
Yes, sir.
All right, thank you. All right, the next item on the agenda is the report of the Subcommittee on Diversity and Inclusion, a subcommittee that many of you, if not all of you, know I actually chaired before becoming an officer and therefore the chair of this Issues Committee. I would like to give that report, and what I'm told that is proper is for me to relinquish my chairmanship to Marcy, the president-elect, and then I will give the report of the diversity subcommittee so that I'm not giving the report to myself. And then once I've concluded, I will then assume the chairmanship again.
Okay.
Correct,
Thank you.
Madam Alice, is that correct?
Yes, that's
Okay.
the right procedure, Todd. Thank you.
Unless she doesn't give it back.
Well, I suspect she will want to give it back.
Oh, yeah. All right. Okay. Hi, everybody. I got my dogs trying to get in my lap. Hold on a second. All right. All right. So Todd is, Todd's committee is the subcommittee on diversity and inclusion, and they have done a lot of work as well. And Todd, if you would, as the chair of that subcommittee, if you would please give your report.
Thank you, Madam Chair. I'll start by saying, as I always do when I talk about these issues, to me, in my 35 years, and I've done a lot in this field, diversity and inclusion and equity, they, for lack of a better phrase, involve a marathon and not a sprint. And I thought back this morning, I was asked to get involved in the state bar in 2010 by Bonnie Wire, past president, and one of her tasks at the time was to improve diversity and inclusion of all stripes, political, geographic, lawyers of color, et cetera, on the state bar, because she felt that there was a need there. And having become an advisory member of the ethics committee and having shown up at my first meeting in 2010, I agreed, looking around the room, I agreed that the state bar could use some help in that department. And so we've been working at it since then. I think we've made lots of progress, but again, it's a journey, and we're still on that journey. Hopefully, with some of the recommendations that this wonderful subcommittee has done, we're getting closer to being able to maybe declare that we're sort of getting near critical mass at the D&I and equity standpoints and perspectives, and we won't have to continue having this discussion, but I dare say that we will continue. In any event, I will say that in my view, consistent with what we just decided, implementation of successful diversity and inclusion measures require great intentionality. They require great deliberation, robust discussion, and to make sure that everybody is on the same page, and they require transparency, scrutiny, among other things. And so I'm going to tell you now about the work that we have done that I believe fits within what I just described in terms of trying to arrive at very specific recommendations that we will make for consideration by the Issues Committee. And so in 2020, the state bar officers responded to a request from the board, from the LAP board, to address certain diversity and inclusion issues. They asked us to take a look at a list of items, quite frankly, and then we responded favorably by responding to them to say that we will indeed consider your recommendations and your request, and we will appoint a subcommittee to address it. Those materials are in your on SharePoint, and you can read all of the materials that the LAP board sent us, the officer's response, and all of the other documents that we, the subcommittee, looked at as we did our work to make these recommendations that I will share in a few minutes. And I do want to give my public appreciation for the members of the subcommittee who are all in the materials as well. And especially Leonore Hodges, who's on the call, I believe, who has done just an excellent job of guiding us throughout this process and instrumental to making the recommendation that you will hear in a moment. The subcommittee met 7 times from January after being appointed in December by President Christie at that point. And we had our last meeting in October of 2021. Several, as I said earlier, were by Zoom. And then the latter ones were in person and were very, very superior to the Zoom meetings in terms of having a robust discussion. And I was able to look around the table and see some people rolling their eyes at some of the things that were being said. And so I called on them, quite frankly. But I thought the discussion was much superior to the Zoom versions. And so we met 7 times over the course of 10 months or so. We studied lots of materials. We studied what other bars had done in a similar approach. We determined that our goal was basically to look at the diversity and inclusion issues relevant to our regulatory task and to come up with some recommendations. Everything that we did was consistent with the parameters that are permitted by the Keller versus State Bar of California decision in terms of what a regulatory agency like ours can do in this regard. We heard from the president of the Missouri Bar, who embarked upon a similar approach in part after the incidents in Ferguson. So we heard from Dana Cutler, the past president of Missouri Bar then. We looked at reports from professors and scholars in this area. We looked at the reports of the states of Florida, Utah, Oregon, among others. We heard from a lot of different stakeholders as we did our work and decided what we would make in terms of recommendations. We also decided that we should take a look at a diversity statement that will be the diversity, equity, and inclusion statement of the State Bar among our other recommendations. So we have a statement for adoption, proposed adoption, as well as our other recommendations. We held our final meeting in, as I said, in October, and we stacked hands, if you will, on the recommendations and the language of each of our recommendations. And so I will share with you those recommendations again, specifically so that you can know what our 9 specific recommendations are. And they're fairly straightforward, so I will sort of read them in order. The first recommendation is that we adopt a diversity, equity, and inclusion statement. It is fairly lengthy. It is in your materials, and so I will not read it verbatim, but suffice to say that we believe that it captures the issues involved in diversity, equity, and inclusion, and makes them consistent with the North Carolina Constitution, the Constitution of the United States. And we also recognize in that statement, proposed statement, that diversity, equity, and inclusion will become, and we will be considered core values of the North Carolina State Bar, and that they will be incorporated and we'll be intentional about incorporating them into our mission and our operations. And if as I go along, someone wants me to read that statement into the record, I will, but I will leave it for you to read because it's in your materials. The second bullet point or recommendation dealt with education, training, et cetera, of ourselves and as our new counselors as well. And so it is to incorporate diversity, equity, and inclusion education, including implicit bias, into the State Bar's orientation programs for new State Bar counselors. We felt like as we brought new counselors on and we orientated them, we could include that component into the training, which we will do if it is accepted by the Issues Committee. The next recommendation deals with the existing policies, procedures, practices, culture, environment that exist at the State Bar. And the specific recommendation is that we analyze the State Bar's current policies, procedures, practices, workforce, work environment, culture, personnel, et cetera, to assess diversity, equity, and inclusion enhancement opportunities at all levels, obviously conceding that our State Bar has already been and is being intentional in that regard, and we're looking for enhancement to the extent it may be necessary or needed. The next recommendation relates to whether or not we capture certain demographic information consistent with our mission, not for the sake of just capturing it, but for the purpose of carrying out our mission. And so that is simply to add questions regarding demographic information, and we're specific here. Race, gender, and age are the categories. To the State Bar members' annual registration form effective for the 2023 due cycle, which includes appropriate opt-out provisions, and consider adding other categories listed in our diversity, equity, and inclusion statement to the extent inclusion of such additional categories furthers the State Bar's regulatory function. So it's a very specific needs-only basis in terms of, I guess, gathering demographic information of our members. And also, more importantly, it is a self-identification because you have the ability to opt out should you desire not to provide it. The next recommendation is similar to the previous one. We have some excellent CLE board and CLE providers doing things in this area already. And again, we want to make sure that we can bolster those and make them more robust to the extent that we find that necessary. And here's the recommendation. Encourage the CLE board and CLE providers to develop robust and engaging CLE offerings on matters of diversity, equity, and inclusion, cultural awareness, and implicit bias, and to identify lawyer presenters from historically underrepresented groups. We hope that is fairly self-explanatory. The next recommendation is sort of consistent with what's happened on the federal level. As you know, the Juneteenth holiday has been made a national holiday in the United States. And so we thought that we would, at a minimum, recognize that it is not a paid holiday in North Carolina, but our recommendation to the Issues Committee is as follows. Recognize Juneteenth and other state holidays by issuing an internal written acknowledgement of the holidays for staff. And again, we are not singling out Juneteenth. We thought that if we're going to recommend one, we're going to recognize one specific holidays, and we ought to also recommend others to the extent that the bar deems that appropriate. So that's our next recommendation. We also talked about ensuring access to our public protection programs. And so we're recommending this. Ensure all persons, including English language learners, have access to the State Bar's public protection programs. Again, we hope that is self-explanatory. And then we wondered about whether or not and to what extent the work of this great committee should be continued. Because these are recommendations, and if they are accepted, then there will be additional work required by the Issues Committee, and maybe that needs to be approved on up the ladder as well. And so we believe that if the Issues Committee accepts this recommendation, it may want to continue the good work of this subcommittee. And so this is what we recommend. Continue the work of the diversity and equity, continue the work of the diversity and inclusion subcommittee, including changing its name to Diversity, Equity, and Inclusion Subcommittee to reflect its scope of work more accurately, i.e. to include specifically the word equity as well. Continuing, to study, among other things, whether a diversity, equity, and inclusion staff position and diversity, equity, and inclusion standing committee of the State Bar should be created. Again, recommendations for the Issues Committee and ultimately the Bar to decide how we should continue and in what manner we might want to continue the work that has been started by this subcommittee and the recommendation we're making. And then the final one, you all, it's similar to what the Bar Association has done, and quite frankly, a lot of other institutions have done around the country. And it is to take a look at the history of the State Bar in terms of any systemic racism and things of that nature that we may want to take steps to eliminate any current vestiges if they exist. And so here is the specific recommendation: to study, research, and prepare a written report identifying relationships between the North Carolina State Bar and systemic racism in North Carolina, including recommendations for eliminating any current vestiges of racism. Again, we believe that should be self-explanatory, but we're happy to discuss it if need be. But again, these are very specific and very far-reaching recommendations in many respects, and we fully understand that folks are not of one mind in this area, and folks have legitimate reasons in their mind for wanting to agree to disagree or to agree with respect to matters relating to diversity, equity, and inclusion. And so we want to give folks a very open and honest and transparent opportunity to debate those and let us hear their views and have those views considered as we make these recommendations to the Issues Committee. And so, Madam Chair, I'd like to say that, these recommendations we believe have been thoughtfully studied and reviewed by the D&I subcommittee. We believe they are consistent with our charge by the Issues Committee. And importantly, we believe that they are consistent with the parameters that are established by the Keller decision for a regulatory body such as ours in this area of diversity, equity, and inclusion. And so the D&I subcommittee recommends them for acceptance to the Issues Committee of the State Bar. That is our recommendation.
Okay, thank you, Todd. We do appreciate all the hard work from both you and your committee and your staff. Leonore, there you are down there. Okay, I believe I see a hand. Catherine Fry.
Yes, thank you, Marcy. I was on the committee that Todd led, he did an amazing job. And I believe I understood some of the comments that he dropped in his introduction. And so I'm going to make the same motion that Mac made. I think this particular issue deserves in-person discussion. By far, when we had the in-person meetings, we had the most thoughtful discussions, and based on the recommendations, and I think just the way I saw our subcommittee fall out, again, I think this deserves an in-person discussion. And so I'd like to make a motion to postpone this discussion until the April meeting.
Thank you, Catherine. I think Julie, did you second that? Okay, thank you. I appreciate that. Okay, are there any in discussion? Peter, you can help me see if the yellow hands go up. Now's the time if anybody would like to make a comment or ask any questions on the motion.
I do not see any hands, Marcy.
Okay. All right, I'm giving you like 5 more seconds. All All right, seeing no hands, I'll call the question. And is there all those in favor? There's the poll.
And that's unanimous, yes.
Okay, thank you. I appreciate it. And again, Todd, thank you and your committee and Leonora for all of your hard work. And we look forward to the robust debate that lawyers are good for in April. All right. I guess I get to turn it back over to you, Todd.
I guess I can't leave it with you, so I will accept and resume the chairmanship of the Issues Committee. Thank you very much for your attention and the decision that you made to postpone these very important matters to the April meeting. Again, I do believe that we will benefit from not only study between now and then by the members of the Issues Committee, the other members of our council, and also by those who are very, very interested in this topic, who might be watching by YouTube, who really can't comment by YouTube, but who can show up in April. And if it's the pleasure of the chair, they will be heard at that time. And it probably will be the pleasure of the chair to hear folks who want to be heard, because I believe in complete transparency. So thank you all very much for your decision to postpone these two issues until April. All right. The final matter on the agenda today is consideration of whether to study attorney deserts. It's a fascinating topic. I've read a good bit of the materials that are in your materials, and I know it is a topic near and dear to President Jordan's heart as well, and many others. And so I believe we're going to hear some background information from staff, Alice, Peter, and/or Brian, and then we shall talk about whether we as a Issues Committee believe that it is something that we should appoint a subcommittee to study, as we have appointed subcommittees to study other very important issues for the state of North Carolina, and consistent with our charge of protecting the public. So Alice, I don't know who has this initially, or whether you're tag team in it, but I turn it over to you initially.
I do, and I wondered if Darren wanted to lay the groundwork, since this was really his proposal, that this be something we look into, and then I can just really sort of tell people what my initial research showed in the articles that I included in the agenda.
Mr. President?
Just so everybody doesn't think that we go off to ABA meetings and snooze and party and all that. When we were down in Florida in October, I had a good, robust conversation with a couple of the bar presidents from the Southern Conference. And one of them was the bar president from the state of Texas. And we started talking about issues about bringing young lawyers into small firms, into rural areas. And I won't say that Salisbury is as rural as probably Eastern North Carolina, but we are a small to medium size county. And my law firm in particular is having trouble finding lawyers to come to Salisbury to work. We have the work, we don't have the people. And it's just a situation that I think is very concerning, because we had a meeting with Chief Justice Newby this morning, and I used the example that we have at best 2 lawyers in town that do, maybe 3 lawyers in town that do bankruptcy. And 2 of those lawyers have a foot and a half out of the law practice, and another one probably will soon be out of the law practice. And so we won't have anybody in Rowan County who practices bankruptcy, who can file bankruptcies. And it's a shame that, and it's an access to justice issue, that those people in Salisbury will have to go to Charlotte or Winston-Salem or somewhere like that to get a lawyer to represent them on a bankruptcy if they want to file one. And that's just one area. I mean, there's many areas that, in the practice of law that I think we're going to run into issues. And I think probably if you go up into the mountains, it's probably a little worse. If you go out east, probably in the sand hills, it's probably doubly bad. So I think it's something we need to look at to see if there's anything the state bar can do. And I think Chief Justice Newby had a couple of good ideas that we could start with, which was essentially a mentoring program of law students, bringing them in for half a summer. Sometimes you don't even have to pay them. I think morally, we probably ought to give them a few dollars, but some of them that he used that as an example of bringing them into your county and showing them what a small town practice is and the fact that it can be lucrative. And they can do all the things that they would like to do other than stay in downtown Charlotte or whatnot. But we need lawyers in Salisbury and some of these smaller communities. And I hope that we can study that and maybe come up with some solutions that might help our access to justice issue. So thank you.
Thank you, Mr. President. Alice, I'll turn it back over to you.
Yeah, and I was just looking at the time, Todd, so I'm just going to be really brief.
Okay.
What I found, I was sitting next to Darren when he was talking with the Texas president, and I thought this was a really interesting subject, and I thought it also really dovetailed into this, the things that the Regulatory Change Subcommittee has been looking at in terms of access to justice, and also what we saw from the Civil Legal Needs Assessment that came out this past year. And I just did a little Googling on the whole topic of attorney deserts, and the 4 articles that I included in the Issues Committee agenda is just kind of the beginning of it. This is something that there actually is a fair amount of information out there. There's a lot of detailed research that's been done, and there's a lot of ideas floating around. The ideas range from what Darren is talking about to the Georgetown article says we need federal funding. I don't know that State Bar can get involved in advocating for that, but there's a lot of ideas out there that are very worthy of further investigation. And Peter actually has done a spreadsheet where he shows what the population to lawyer ratio is by county. I think that's what he's going to share with you right now. And Peter, I'll hand the baton over to you if you want to tell people what they're looking at.
Yeah, this is a very quick breakdown. Is just kind of a proof of concept of the data that we can look towards and pull together. This is a breakdown of counties based off of the number. This is currently filtered by lawyers per 1,000 residents. And I know that in some of the ABA articles, they focused on having a lawyer per one, anybody who has under 1 lawyer per 1,000 residents could be, something of concern as it relates to a desert. And so we actually have 48 counties in North Carolina that have fewer than 1 lawyer per 1,000 residents. Starting at Camden County being, very low. And it's not necessarily just the smallest counties. You have, some of the bigger counties just don't have as many lawyers as you might think that they should. And then right at the cutoff here, in terms of if you're looking at 1,000 residents, you have Pender and Robeson County that are, right there on the line, going all the way down to Wake, Mecklenburg, Durham, and Orange that have large populations, but also significant numbers of lawyers as well. So this is fresh data. I just pulled this today, and so we'll, if this is an issue that the committee wants to continue further study, we'll be able to pull a lot of data in this way and be able to pinpoint and target down some more, look at other ways to identify where these potential gaps are in lawyer representation in North Carolina. And I'll put this in the material in the Issues Committee folder for anyone who wants to look at it.
Thank you, Peter. Thank you, Alice. Being respectful of everyone's time. Any other comments from other folks on the call here about the deserts?
Todd, do you need a motion to create a subcommittee?
I do, and I'm going to call for one. And with your
That's it.
permission, I will consider your question to be a motion that the Issues Committee appoint a subcommittee to study the issue or the topic of attorney deserts in North Carolina.
Okay.
Is that?
That's it.
Okay?
Yep.
All right. Can I
Second.
get a second for that motion? Julie, Judge Bell?
Yes.
Is that- Okay,
Yes, I
second?
did. Julie was
Okay,
fine. That's a
Thank
second.
you. Thank you. Properly moved and seconded. Any discussion? See no hands clicking through. All right, properly moved and seconded. Please vote your views on this motion. All right, that looks like it is unanimous, and therefore it passes. So thank you very much. The next step will be the Issues Committee will take up this recommendation that we appoint a subcommittee, and President Jordan and others will proceed accordingly. That is all of the business that I have on my agenda today. We have 1 minute to spare. Anyone else have anything for the good of the order?
Hey, Todd, this is Heidi. I'm sorry,
Yes.
I'm not on the committee, but quickly, I understand and concur with the decision to push off the discussion to an in-person discussion on the regulatory reform
Yes.
issue, but I would strongly encourage everyone to read thoroughly the report that was submitted and look at the addendums and the attachments and the appendices, because it's a complex, multi-layered issue that I think will all be better for understanding by reading that. So I just wanted to encourage everyone to do that, because I was on the committee for 18 months and it probably took me 6 to figure out what we were talking about half the time. So
Heidi, thank you for that wonderful observation. That is one of the reasons that we wanted to consider whether or not it should be postponed, and you all obviously agreed to do that. And I think we'll find a way to try to make sure that we encourage counselors and others to read the materials between now and then, because we do expect there to be a good open discussion in April, and then also a vote. So that's where we stand. Thank you very much.